Welcome to a recap of our February 20, 2026 newsletter, where we talked about trademarks, franchises, and other legal stuff, and trivia. We also showed a picture of our canine law clerk as usual, and even a cat picture, dare I say, the law clerk of one of our recent trivia winners who received his own Jelly of the Month subscription. You can see a link to our most recent edition of the newsletter in the description below. In it, we covered Taylor Swift and Travis Kelce's pre-wedding trademark jitters, no more living a lie with boneless wings from Buffalo Wild Wings, and actually for this video edition we tried something new and went on site to a B-dubs. What is a trademark class? We answered that frequently asked question. I'm Tom Vanderbloemen. I'm a lawyer in South Carolina, and our firm focuses on trademarks, franchises, plus other patent, copyright, and business law matters. If you like this kind of stuff, or if you're just interested in trivia and dog pictures, like and subscribe to the video in our channel and sign up for our newsletter using the link in the description below. We're actually going to take these topics out of order because we had the chance to go on the scene for reporting from Buffalo Wild Wings. After all, it's probably easier to drive to the B-dubs than it is to get to a Taylor Swift concert or to a Kansas City Chiefs game. So bear with us as we splice in our report from the field. Well, no more living a lie with boneless wings. Longtime readers will recall our prior coverage of the various false advertising allegations surrounding boneless wings, including the class action lawsuit claiming that Buffalo Wild Wings was deceiving customers through the sale of boneless wings. Earlier this week, a federal judge dismissed the case, finding that there was no consumer deception from this term, boneless wings. And for what it's worth, we paid a visit to our local B-dubs. And we didn't see too many deceived customers inside, although I guess if you're being deceived, you may not really realize it either. So if we talk about trademarks a lot, why bring this up here? The court did make some comments that made us think of trademark law. For starters, the court was skeptical that the term boneless wings was really literally false anyway. That's an element of the claim. Because words can have multiple meanings. Indeed, the term buffalo wing refers to the type of sauce on the wing, rather than indicating that it's made out of buffalo meat. Of course, in trademark law, we frequently run into multiple meanings of words as well. In any event, the court said that the term boneless wing was not misleading either, because a boneless wing was a fanciful name, like a cauliflower wing, which is also on the menu. And that's because real chickens and real chicken wings do have bones. Now, we often talk about fanciful terms in trademark law too. Those are made-up terms. And since those terms can often be strong trademarks, we like to see fanciful terms from our clients when we're doing trademark applications. We also run into terms that are sometimes called incongruous, that are words or phrases that have terms that don't seem to belong together, like a boneless and a wing. Now, that's not to say that a boneless wing is a trademark. I mean, after all, the court said that boneless wings are not some niche product that a consumer would need to do a lot of research on. Instead, boneless wings is a common term that has existed for over 2 decades. But the fact that it's a fanciful term illustrates what the court was saying, that no reasonable person would take it literally, any more than saying a buffalo wing is made out of buffalo meat, or that chicken fingers were made out of fingers from chickens, or that cauliflower wings meant that cauliflowers had wings. False advertising cases and trademark cases also share overlaps. The federal statute that governs trademark cases also contains a section raised in many false advertising cases. And false advertising cases and trademark cases can share many of the same remedies. Also, false advertising cases and trademark cases often rely on state law, like unfair and deceptive trade practices statutes. Despite Buffalo Wild Wings' celebrations of the ruling, the plaintiff will get a second bite at the wing. The judge is giving him an opportunity to amend his complaint, even though, as the court said, it is difficult to imagine that he can prove additional facts to show deception. This also made us think about the man from Lincoln, Nebraska, who went to his city government with a rant about boneless wings. He claimed the public had been deceived and living a lie for far too long over the name and proposed alternative names like Saucy Nugs. You can see a link to his public comments in the description. So whatever you call them, go enjoy those wings or those nugs and try not to be deceived. More news about Taylor Swift and Travis Kelce? Not wedding news, but trademark news. Yes, Swifties and Chiefs fans, your favorite couple is hot on the street with recent news about their trademarks, not the wedding. Whether you're here for the bride or the groom, each of them has a trademark issue. Let's talk about the bride. Ms. Swift's licensing company recently opposed a trademark application by Kathy Home, which is a company that has a Swift Home line of bedding products. That company already actually has a trademark registration for one of its Swift Home logos, and there are other Swift trademarks owned by other companies out there, like a trucking company called Swift Transportation. So what's the deal with the new application? Well, apparently Ms. Swift's team does not care for Kathy Holmes' new logo, as shown in the opposition papers that her company filed. According to Rolling Stone, Kathy Holmes' lawyer says that his client had a consent to coexist agreement with Ms. Swift's team over the previously registered trademark, but that it won't pursue this new application any further. The lawyer explained that the new logo is not really essential to the company's business and added, quite understandably, that such decisions are often practical and commercially sensible. In other words, stay out of Ms. Swift's way. For the groom, the trademark issues. Mr. Kelce is making his own trademark news, having been sued over the name of a new steakhouse. He and Kansas City Chiefs teammate Patrick Mahomes have opened a restaurant called 1587 Prime, a nod to their combined jersey numbers, Mahomes being 15 and Kelce being 87. They're being sued by a company called 1587 Sneakers. It's a shoe and apparel company in New York. That company, which claims to be the first sneaker brand in the U.S. that's owned, designed, and inspired by Asian American culture, appears to have selected this 1587 term in reference to the year that Filipino sailors first arrived in what is now the United States, what the company says is the earliest recorded presence of Asians in America. The sneaker company believes that the high-profile steakhouse and its related apparel using 1587 would overshadow it and cause it irreparable damage, forcing the company, as it alleges, towards a cliff of collapse. The sneaker company also refers to clear Asian-inspired and influenced dishes and ingredients peppered throughout the menu at the restaurant. They see this as evidence that the restaurant is trying to, quote, mirror and invade the same thematic commercial space that the plaintiff has. To us trademark nerds, what's really interesting about this case is the law school-like fact pattern we have here, specifically the dates. In the trademark world, the first company to adopt and use a trademark is often called the senior user, and it generally has prior rights over the later or junior users, subject, as always, to limits. Things can get kind of funny when the junior user files the trademark application first, before the senior user. Now, according to the complaint, that's what it looks like happened here. The Mahomes-Kelce restaurant filed its 1587 Prime applications in 2023 and 2024, and a registration for its logo was just issued this month. Those applications claim dates of first use in 2025, and that's because under federal trademark law, you can file a trademark application before you actually started using the trademark. The sneaker company, however, filed its applications in 2025, after it had begun using its trademark. It claims to have used the 1587 trademark at least as early as April 13, 2023, before the restaurant. So another wrinkle to this case, beyond the dates and who filed first, is that the trademark applications for the restaurant cover restaurant and bar services, but it's really the apparel that seems to be the target of the new lawsuit. Many restaurants sell some kind of merchandise. It's almost like advertising. But given the notoriety of the Mahomes-Kelce pair, which of course is not the same notoriety as the Swift-Kelce pair, the restaurant's merchandise could have its own significance beyond steakhouse fanatics. By the way, Taylor Swift is a prolific trademark filer with hundreds of filings in the United States. The upside to that is if you don't manage to get her autograph at one of her concerts, you can just visit the trademark office, where she had to personally sign consents to the registration of her name. A frequently asked question we get is, what is a trademark class? While it may sound like a place to go learn about trademarks, what we really mean here is the classification system that the U.S. Patent and Trademark Office uses for trademarks. Trademark applications should list the goods and services with which the trademark is used or will be used. The U.S. Trademark Office groups these goods and services into classes based on an international classification system. That classification system is called the NICE classification, not the NICE classification, though it isn't necessarily unfriendly either, but the NICE classification system because it stems from an agreement signed in Nice, France in 1957. Well, apparently trademark law likes fancy cities because there's also a Geneva Act and a Stockholm Act that are related to the NICE classification system. The system has 45 classes. For example, automobiles are in class 12, while shoes are in class 25. Services like live entertainment are in Class 41, and sometimes the correct class is not even always evident, and the examiners have to require applicants to split up their goods and services across multiple classes. This whole regime can lead to other questions, like how many classes should I file in? Is my trademark okay if I file in a different class than someone else who is registered with the same trademark but in another class? The classes can make searching and grouping easier, but they don't necessarily limit a trademark owner's rights, since trademarks in different classes can still be conflicting. For example, trademarks used on clothing, which falls in Class 25, they can sometimes conflict with similar trademarks used on luggage and bags, which fall in Class 18. As to how many classes to file in, sometimes this is a balance of different factors. Cost is a big one, since more classes means more cost, both to file the application and to maintain a registration if you get one. And while trademarks in different classes can still be conflicting, sometimes applicants do hold off on filing in certain classes if there are registrations for similar marks, with hopes of avoiding obvious refusals and conflicts. A big consideration is whether your business will actually use the trademark on all these different goods and services. While you can file a federal trademark application before you are actually using the trademark, at some point you will need to be using the trademark for all the things listed in the application. You'll also need to provide some level of proof that you're using it, and you could be subject to an audit. So sometimes it's best to stick to the business's core goods and services. How do you know what goods and services fall in what classes? The U.S. Trademark Office has a handy trademark ID manual that provides a good starting point. We'll provide a link to that tool in the description below, along with a link to a full listing of the classes. If you like this kind of stuff, trademark, franchise, other IP and business law, or even if you don't like this kind of stuff, but you just like trivia and the occasional dog picture, you can like this video and subscribe to our channel, and you can sign up for the newsletter using the link in the description. We hope you enjoy.